Hi, welcome back. This is part 3 of hazardous waste management, and in this session we are going to discuss about hazardous waste management, handling and TransBoundary movement rules of 2008. The rule 2 discusses about the application. So these rules shall apply to the handling of hazardous waste as specified in schedules and shall not apply to a wastewater and exhaust gas as covered under the provisions of the Water Prevention and Control of Pollution Act of 1974, then waste arising out of the operation from ships beyond 5 kilometers of the relevant baseline as covered under the provisions of Merchant Shipping Act 1958, then third, radioactive waste as covered under the provisions of the Atomic Energy Act of 1962, then fourth one, biomedical waste covered under the Biomedical Waste Management and Handling Rules of 1998, and waste covered under the Municipal Solid Waste Management and Handling Rules of 2000. So, the second rule is about application, and it gives us a list of where the hazardous waste management, handling and transboundary movement rules of 2008 is not applicable, and this includes the provisions under the Water Prevention and Control of Pollution Act, then the Merchant Shipping Act of 1958, then we have Atomic Energy Act of 1962, then Biomedical Waste Management and Handling Rules 1998, and last the Municipal Solid Waste Management and Handling Rules of 2000. Now the rule 3 is with respect to definitions, and it includes authorization, which means permission for generating, handling, collection, reception, treatment, transport, storage, recycling, reprocessing, recovery, reuse and disposal of hazardous waste are granted under subsection 4 of rule 5. And here a Basel Convention is defined, that is the United Nations Environmental Programme Convention on the Control of Transboundary Movement of Hazardous Waste and their Disposal. Then we have Central Pollution Control Board, which means the Central Pollution Control Board constituted under subsection 1 of section 3 of the Water Prevention and Control of Pollution Act of 1974. Then disposal means any operation which does not lead to recycling, recovery or reuse and includes physico chemical, biological treatment, incineration and disposal in the secured landfill. Then we have export, with its grammatical variation and cognate expression means taking out of India to a place outside India. Then we have the definition for exporter. Then we have environmentally sound management of hazardous waste. So environmentally sound management of hazardous waste is defined as it means taking all steps required to ensure that the hazardous waste are managed in a manner which shall protect health and the environment against the adverse effect which may result from such waste. Then we have environmentally sound technologies, which means any technology approved by the central government from time to time. Then we have facility, which means any establishment wherein the process incidental to handling, collection, reception, treatment, storage, recycling, recovery, reuse and disposal of hazardous waste are carried out. Then we have hazardous waste, that is the subclause L of rule 3. Subclause L of rule 3 defines hazardous waste. That means any waste which by reason of any of its physical, chemical, reactive, toxic, flammable, explosive or corrosive characteristic cause danger or is likely to cause danger to health or environment, whether alone or when in contact with other waste or substance, and shall include 1. Waste specified under column 3 of schedule 1. 2. Waste having constituents specified in schedule 2 if their concentration is equal to or of more than the limited indicated in the said schedule, that is schedule 2. Now the third one is waste specified in part A or part B of schedule 3 in respect of import or export of such waste in accordance with rules 12, 13 and 14 or the waste other than those specified in Part A or Part B if they possess any of the hazardous characteristics specified in Part C of Schedule 3. Now we have hazardous waste site, which means a place of collection, reception, treatment, storage of hazardous waste and its disposal to the environment, which is approved by the competent authority. Then definition for importer, manifest, occupier, operator of disposal facility, other waste, recycler or reprocessor or actual user, recycling, reuse, recovery, state pollution control board, storage, etc. are given in definition, that is rule 3 of the rules. And here we also have transboundary movement defined, which means any movement of hazardous waste from an area under the jurisdiction of one country to or through an area under the jurisdiction of another country, or to or through an area not under the jurisdiction of any country, provided at least two countries are involved in the movement. So transboundary movement is defined in clause ZA of rule 3. So rule 3 of hazardous waste management, handling and transboundary movement rules 2008. Rule 3 is with respect to definitions, and rule L defines what is hazardous waste. Rule 3 subclause L defines what is hazardous waste, and subclause ZA of rule 3 defines transboundary movement. And we have other definitions such as exporter, importer, occupier, recycling, reuse, recovery, then storage, transport, treatment, etc. under the rule 3, that is with respect to definition. And rule 4 is with respect to responsibilities of occupier for handling of hazardous waste. So here rule 4 clause 1, that is, the occupier shall be responsible for safe and environmentally sound handling of hazardous waste generated in his establishment. Clause 2, the hazardous waste generated in the establishment of an occupier shall be sent or sold to a recycler or reprocessor or reuser registered or authorized under these rules, or shall be disposed of in an authorized disposal facility. And rule 3, the hazardous waste transported from an occupier established to a recycler for recycling or reuse or reprocessing or to an authorized facility or disposal shall be transported in accordance with the provision of these rules. And rule 4, the occupier or any other person acting on his behalf or who intends to get his hazardous waste treated and disposed of by the operator of a treatment, storage and disposal facility shall give to the operator of a facility such information as may be determined by the State Pollution Control Board. And the 5th clause is that the occupier shall take all adequate steps while handling hazardous waste to 1, that is first condition, that is contain contaminants and prevent accidents and limit their consequence on human beings and the environment, and 2, to provide persons working on the site with training, equipment and information necessary to ensure their safety. So the chapter 2 deals with procedure for handling hazardous waste, and this is discussed in rule 4, 5, 6 and 7. So chapter 2 deals with procedure for handling hazardous waste, and it is dealt in rules 4, 5, 6 and 7. Rule 4 is with respect to responsibilities of the occupier for handling hazardous waste, and rule 5 is with respect to grant of authorization for handling hazardous waste. Then we have rule 6, which is about the power to suspend or cancel an authorization, and with rule 7, storage of hazardous waste. And next in chapter 3, it is with respect to procedure for recycling, reprocessing or reuse of hazardous waste. Chapter 3 is with respect to procedure for recycling, reprocessing or reuse of hazardous waste, and that is discussed in rule 8, 9, 10 and 11. So rule 8, 9, 10 and 11 deals with procedure for recycling, reprocessing or reuse of hazardous waste. Then we have chapter 4, which is with respect to import and export of hazardous waste. So chapter 4 is with respect to import and export of hazardous waste, and it is dealt with in rule 12 to rule 17. Rule 12 to rule 17 deals with import and export of hazardous waste. Then we have chapter 5, which deals with treatment, storage and disposal facility of hazardous waste. So chapter 5 is with respect to treatment, storage and disposal facility of hazardous waste, and that is discussed in rule 18. The whole chapter is discussed only with rule 18. Then we have chapter 6, that is with packaging, labeling and transport of hazardous waste. So chapter 6 is with packaging, labeling and transport of hazardous waste, and discussed in rule 19 to rule 21, that is inclusive of rule 21. So packaging, labeling and transport of hazardous waste is chapter 6, and rule 19 to rule 21, which is inclusive of rule 21. And chapter 7 is a miscellaneous part, and that is from rule 22 to rule 26. So chapter 7 is miscellaneous, that is rule 22 to rule 26, and rule 26 is with respect to appeal. So with miscellaneous, what is covered in miscellaneous is rule 22, that deals with records and returns. Rule 23, that is responsibility of authorities. Rule 24, accident reporting and follow-up. Then rule 25 is the liability of the occupier, transporter, operator of a facility and importer. And rule 26 is with respect to appeal. And with respect to appeal, here we have the first clause, rule 26 clause 1. Any person aggrieved by an order of suspension or cancellation or refusal of the authorization or its renewal passed by the State Pollution Control Board may, within a period of 30 days, please note, a period of 30 days from the date on which the order is communicated to him, prefer an appeal in Form 15 to the appellate authority comprising of the Environment Secretary of the state. So that is rule 26 clause 1. Now clause 2, any person aggrieved by an order of suspension or cancellation or refusal of registration or its renewal passed by Central Pollution Control Board may, within a period of 30 days from the date on which the order is communicated to him, prefer an appeal in Form 15 to the appellate authority comprising of the Secretary to the Government of India in Ministry of Environment and Forest. Now clause 3, the appellate authority may entertain the appeal after the expiry of the said period of 30 days if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time. Now clause 4, every appeal filed under this rule shall be disposed within a period of 60 days from the date of its filing. So with respect to appeal, that is discussed in rule 26, the clause 1 is with respect to any orders, appeal from any orders or decision from the State Pollution Control Board, and the time period for appeal remains same for appeal from decision of State Pollution Control Board as well as central Pollution Control Board. For both, the time period is 30 days. While giving the appeal, it has to be by Form 15 to the appellate authority. When it is with respect to State Pollution Control Board, the appellate authority shall comprise of the Environment Secretary of the state, whereas in case of Central Pollution Control Board appeal from order or decision of the Central Pollution Control Board, it should be within 15 days within 30 days by use of Form 15, but the appellate authority is comprising of the Secretary to the Government of India in the Ministry of Environment and Forest. So State Pollution Control Board is discussed under clause 1 and Central Pollution Board under clause 2, and in clause 3 what is discussed is if there's a sufficient cause for delay in preferring an appeal, then the authority may permit it. That is discussed in clause 3, and in clause 4 it is discussed that every appeal filed under this rule shall be disposed within a period of 60 days. So that is with appeal. So under chapter 7 miscellaneous, we have rule number 22, that is records and returns. Then rule 23, responsibility of authorities. Then rule 24, accident reporting and follow up. And rule 25, liability of occupier, transporter or operator of facility and importer. And rule 26 is the appeal. So appeal, the time period for appeal remains the same, that is 30 days with respect to state pollution control board as well as central pollution control board, and in both scenario we have to use the form 15. But when it is with respect to state pollution control board, we have to the appellate authorities comprising of the environment secretary of the state, and with respect to central pollution control board, the appellate authority is comprising of the environment secretary to the government of India in the Ministry of Environment and Forest. And then if a person is preferring an appeal beyond the permitted or given 30 days period, then he have to show sufficient reason, and it is a discretion of the appellate authority. It is not a right but a discretion. And by fourth, it is said that the any appeal preferred under this rule shall be disposed within a period of 60 days from the filing. And with respect to liability of occupier, transporter, operator of a facility and importer, that is in rule 25. Here clause 1, the occupier, importer, transporter and operator of the facility shall be liable for all damages caused to the environment or third party due to improper handling of the hazardous waste or disposal of the hazardous waste. Now clause 2 says that the occupier and the operator of the facility shall be liable to pay financial penalties as levied for any violation of the provision under these rules by the State Pollution Control Board with prior approval of the Central Pollution Control Board. So that is with respect to the liability, and that comes under chapter 7 in the miscellaneous, and that is rule number 25. So coming back, we already discussed about rule number 4, that is in chapter 2, which deals with procedure for handling of hazardous waste. The responsibility of the occupier for handling of hazardous waste was discussed in rule 4, and the liability of the occupier for in transport etc. is discussed in rule number 25. Now rule number 5 discuss about grant of authorization for handling hazardous waste. So the power to grant authorization is with the State Pollution Control Board, and every person who wants an authorization from the State Pollution Control Board shall submit an application in Form 1 to the State Pollution Control Board, and it is a mandatory process. Only one proviso is given, that if any person authorized under the provisions of the Hazardous Waste Management and Handling Rules of 1989 prior to the date of coming into force of these rules, that is 2008 rules, such a person shall not require to make an application for authorization till the period of expiry of such authorization. And it is to be noted that once the application is submitted, the State Pollution Control Board will conduct such inquiry as it deems fit. And what will be the criteria for inquiry? That is, if there is appropriate facilities, technical capabilities and equipments to handle hazardous waste safety, then if the State Pollution Control Board is satisfied, if all the conditions or all the necessities or requirements are met, then after such inquiry it may grant an authorization within 120 days. That is after the 120 days including the inquiry, and this authorization is given by Form 2 to the application, which will be valid only for a period of 5 years. So the authorization is valid only for a 5 years, and then the person can renew it. Now even before this period of 5 years, if the board is convinced that there is a issue or non-compliance, this authorization is given by laying down some of the conditions to be met. If the board is convinced that there is no compliance with either any of the conditions, or if there is any discrepancies in the informations given, then the Pollution Control Board can revoke the authorization after giving a reasonable opportunity of being heard. Now, so I said there is conditions. So these conditions has to be maintained in a register. that the State Pollution Control Board shall maintain register containing particulars of conditions imposed under each case. Now, the state, every person authorized under these rules shall maintain the record of hazardous waste handled by him in Form 3, and this shall be submitted to State Pollution Control Board. Along with it, they also have to submit an annual report, that is Form 4, and this should be submitted before 30th day of June of the following financial year. Now, the application for renewal is also Form 1 as granting of authorization, the same form, and it has to be given before the expiry of the current authorization. So that is with grant of authorization, that is discussed under Rule 5. So the chapter 2 deals with procedure for handling hazardous waste, and that is from Rule 4 to Rule 7, where Rule 7 is included in it, and Rule 5 deals with the granting of authorization, and Rule 6 is with respect to power to suspend or cancel an authorization. Now, Rule 6 deals with power to suspend or cancel an authorization, and it is done when there is when the board is convinced that the person who has an authorization has failed to comply with any of the conditions of the authorization, and once the authorization is suspended or cancelled, the State Pollution Control Board may give directions to the person as to how as to the manner of safe storage of the hazardous waste, and the person shall comply with such direction. And Rule 7 deals with storage of hazardous waste. The occupiers, recyclers, reprocessors, reusers, and operators of facilities may store the hazardous waste for a period not exceeding 90 days, and shall maintain a record of sale, transfer, storage, recycling, and reprocessing of such waste, and make these records available for inspection, provided that the State Pollution Control Board may extend the said period in some of the cases. That is 4 scenarios. The first one, small generators up to 10 tons per annum. The second, recyclers, reprocessors, and facility operators up to 6 months of their annual capacity. Then the third, generators who do not have access to any treatment, storage, disposal facility in the concerned state. Or the fourth, the waste which needs to be specifically stored for development of a process for its recycling, reuse, etc. So these are the 4 circumstances where the State Pollution Control Board may extend the said period, or else it is for maximum up to 90 days. The next chapter 3 is deals with procedure for recycling, reprocessing, and reuse of hazardous waste, and this chapter is discussed from Rule 8 to Rule 11. Rule 8 is with regard to procedure for grant of registration, and Rule 9, conditions for sale or transfer of hazardous waste for recycling. Then Rule 10 is with respect to standards for recycling. Rule 11 with respect to utilization of hazardous waste. So Rule 11, the utilization of hazardous waste as a supplementary source or for energy recovery or for processing shall be carried out by the units only after obtaining the approval of the Central Pollution Control Board. So usually we always discuss getting authorization from State Pollution Control Board, but with respect to utilization of hazardous waste and standards of recycling and the conditions for sale or transfer of hazardous waste, all these are controlled by the Central Pollution Control Board. Now chapter 4 is with respect to import and export of hazardous waste, and this chapter is discussed from Rule 12 to Rule 17, inclusive of Rule 17. And chapter 4, Rule 12 is import and export, TransBoundary movement of hazardous waste. So here the Ministry of Environment and Forest shall be the nodal ministry to deal with the TransBoundary movement of the hazardous waste and to grant permission for transit of hazardous waste through any part of India. So it is with respect to, so who is the authority here? That is the Ministry of Environment and Forest, and that is clearly given by Rule 12 under chapter 4. Now Rule 13 is with respect to import and export of hazardous waste, and we have 4 clauses under Rule 13. 1. No import of the hazardous waste from any country to India for disposal shall be permitted. So it is not permitted for disposal. So clause 2, the import of hazardous waste from any country shall be permitted only for the recycling or recovery or reuse. So what is permitted? Recycling or recovery or reuse, and that is mentioned in Rule 13 subclause 2. Now subclause 3. The export of hazardous waste from India may be allowed to an actual user of the waste or operator of a disposal facility with a prior informed consent of the importing country to ensure environmentally sound management of the hazardous waste in question. Now clause 4. No import or export of hazardous waste specified in Schedule 6 shall be permitted. Now Rule 14 is with respect to import or export of hazardous waste for recycling, recovery and reuse. We already discussed that is the only permitted scenario for import, and for disposal, import for disposal is not permitted. While Rule 14 discusses about the procedure for import for the purpose of recycling, recovery and reuse, that is import or export of hazardous waste for recycling, recovery and reuse, discussed in Rule 14. Rule 15 discusses about procedure for export of hazardous waste from India. So procedure for export of hazardous waste from India, and Rule 16 discuss about procedure for import of hazardous waste. So Rule 14 is procedure for export and Rule 16 is procedure for import. And then we have Rule 17, that is illegal traffic. So we have under Rule 17, the export and import of hazardous waste from and into India shall be deemed illegal if 4 conditions as mentioned. The first one, it is without the permission of central government in accordance with these rules, or second, the permission has been obtained through falsification or misrepresentation of fraud, or the third, it does not conform to the shipping details provided in the movement document, or the fourth, it results in deliberate disposal, that is dumping of hazardous waste in contravention to the Basel Convention of the general principles of international or national laws. So in case of illegal import of hazardous waste, the importer shall re-export the waste in question at his cost within a period of 90 days from the date of arrival into India, and its implementation will be ensured by the concerned State Pollution Control Board. So it shall be done at his own cost and within a period of 90 days at the cost of the importer. It should be re-exported. Now the chapter 5 deals with treatment, storage and disposal facility of hazardous waste, and it is dealt in Rule 18. So Rule 18 is the only rule under chapter 5 which deals with treatment, storage and disposal facility of hazardous waste. And then we have chapter 6, that is packaging, labeling and transport of hazardous waste, and that is discussed from Rule 19 to Rule 21, packaging, labeling and transport of hazardous waste. Rule 19 is with packaging and labeling. Then Rule 20 is with respect to transportation of hazardous waste, and Rule 21 is with manifest system, that is movement document to be used within the country only. That is manifest system is discussed in Rule 21. And then we have the chapter 7, which is miscellaneous, which we already have discussed. The important rule under chapter 7 miscellaneous is the rule number 26, that is with respect to appeal, and rule number 25, which deals with the liability of occupier, transporter or operator of a facility and importer. So that is with the end of this session and with the end of hazardous waste management. The rules regarding the rules and procedure of import and export of hazardous waste will be done in a different session. Thank you for your support. Thank you for listening. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update when I upload my next podcast or a video. Thank you. Have a nice day.